A contract is a promise tethered to the future. Two parties agree today on a specific set of duties that must be executed on an agreed-upon date. The standard rule of breach reflects this timeline. An injured party generally cannot file a lawsuit for non-performance until that performance date actually arrives and passes without the promised action. But commercial reality does not always wait for a calendar date. Occasionally, one party will definitively announce they have no intention of honoring the deal, weeks or months before their performance is actually due. When an obliger explicitly renounces their contractual duty at a point prior to that deadline, the law faces a logistical problem. This early refusal is known as an anticipatory repudiation. Anticipatory repudiation alters the temporal reality of contract law. Instead of forcing the non-breaching party to wait in limbo for a doomed deadline, it grants them immediate legal rights to act. This rule traces back to the 1853 English case, Hochster v. Delator, involving a courier packing his bags for a European tour. In April of that year, a traveler hired the courier to accompany him on a 3-month journey scheduled to begin on June 1st. The arrangement was set. Then, on May 11th, the employer wrote the courier an explicit letter canceling the trip and refusing any compensation. Under strict temporal rules, the courier had no actionable claim on May 12th. He would have been legally obligated to sit idle, refusing other work, and remaining ready to perform until June 1st arrived. This textbook excerpt details the mid-19th century shift resolving this dilemma. The court recognized that finding the courier to a doomed schedule was irrational. Instead, it ruled that an absolute pre-performance refusal allows the aggrieved party to bring suit immediately to recover damages for total breach. Forcing an injured party to prepare for a canceled contract is economically wasteful. It requires them to spend money and time on useless preparations. Releasing the non-breaching party immediately allows them to re-enter the market and find alternative employment. That new income actively mitigates the damages the breaching party will ultimately owe. Today, this is codified in Restatement Section 253. A repudiation before the performance date alone gives rise to a claim for total breach, permitting the aggrieved party to suspend their own duties and sue. The Hochster rule is a powerful tool, but utilizing it safely requires undeniable certainty that the other party actually intends to breach. The central tension for a modern practitioner is correctly identifying a repudiation. Misinterpreting an obligor's hesitation as a total refusal carries devastating legal consequences. Looking at this text detailing the legal threshold, we see that the standard is exceptionally strict. The intent to abandon the contract must be definite and unequivocal. The text explicitly states that a party's expression of doubt about its ability to perform is not enough. General anxiety, rumors of insolvency, or even the threat of a minor delay do not meet the threshold. To trigger the rights established in Hochster, the communication must be an absolute positive statement, indicating an inability or complete unwillingness to render the promised performance. This creates a severe risk. If a lawyer hears an ambiguous expression of doubt, assumes the deal is dead, and advises their client to cancel the contract, the client has now committed an unjustified material breach. Misidentifying this legal threshold constitutes professional negligence as a matter of law. By guessing wrong, an attorney effectively induces their own client to breach the contract. We can observe this danger precisely in the 1990 Alaska Supreme Court case, Drake v. Wickwire. This is the official opinion outlining a catastrophic error by an attorney named Wickwire, who was sued by his own client for malpractice. Wickwire represented the seller in a real estate transaction. As the closing deadline approached, the buyer's broker contacted Wickwire to discuss the timeline. The broker noted the buyers had the money, but stated they were resisting the pressure to close. Based entirely on that phrase, Wickwire treated the statement as a repudiation, advising his client to cancel the contract and sell to a different buyer. Wickwire assumed that resistance meant refusal. By acting on that assumption, his client breached the original earnest money agreement. The court analyzed the broker's language and found it facially ambiguous. While it showed hesitation, it fell far short of a definitive statement that the buyers would not or could not pay. Faced with an ambiguous statement, the attorney took the wrong path. choosing to cancel the contract exposed his client to liability. The correct legal mechanism, which the attorney ignored, was to demand assurances. Because Wickwire advised precipitate conduct based on a vague comment, the court reversed summary judgment, finding his actions constituted professional negligence. Drake demonstrates that practitioners cannot rely on assumptions. They must actively secure absolute certainty before authorizing a client to abandon an agreement. To prevent the trap Wickwire fell into, contract law provides a specific tool for resolving pre-performance ambiguity: the demand for adequate assurances. This excerpt explains the mechanism as defined in Uniform Commercial Code Section 2-609. It activates when a party has reasonable grounds for insecurity. This tool bridges the gap. It is used precisely when an obligee has legitimate reasons to doubt the deal will close, but lacks the unequivocal refusal required to sue immediately. The process begins with a mandatory first step. The insecure party must submit a written demand for adequate assurance of due performance. Submitting this demand carries an immediate protective benefit. The demanding party is legally permitted to suspend their own performance, halting their expenditures while they await a response. While originally codified in the UCC for the sale of goods, the logic of this rule is so practical that Restatement Section 251 has integrated it into general common law contracts across many jurisdictions. The requested assurances must be commercially reasonable for the specific transaction. A party cannot use the demand to exploit the situation or extort better terms than originally agreed upon. By sending a formal written demand, the insecure party forces the counterparty's hand. The obligor must either legally recommit to the deal or explicitly break it. The final logistical question is what happens if the obligor simply ignores the written demand, leaving the situation in ambiguous silence. The law does not allow indefinite silence. The moment the demand is sent, a legal timer begins ticking. Under UCC 2-609-4, a failure to provide adequate assurances within a reasonable time, specifically a maximum of 30 days, is treated as a repudiation of the contract. This is a trapdoor. By remaining silent, the counterparty's vague ambiguity is legally converted into a definite, actionable refusal. Once a clear repudiation is established, whether through a direct unequivocal statement or by failing the 30-day trapdoor, the injured party has options. They can utilize the Hochster rule, treating the event as a total breach and filing a lawsuit immediately. Alternatively, they can suspend their own performance, wait to see if the breaching party retracts the repudiation, or affirmatively urge them to perform as promised. The core operational rule is certainty. A practitioner must never act on an assumption of doubt. They must use the demand for assurances to force the crisis, clarify the intent, and secure their client's right to a remedy.